opportunity to speak to you because I do, of course, support the work of the United Nations, but in particular the idea of interfaith. And I think the concept is a very important one, and I'm so delighted to know that there are so many people in Australia who support this idea. But it's also an extremely important time for us to be discussing the question of human rights and the right to freedom of religious expression. Because as you will know, we've had the Ruddock panel report, and the current government now plans, or says it plans, to bring, for the first time at the federal level, a religious discrimination bill to provide what they say is comprehensive recognition or protection for the right to religious activity as recommended by that Ruddock review. Well, as an international lawyer, I have to say that although I have certainly spent the last 5 or 6 years on human rights law, I've only very rarely been asked to speak about religious freedoms. And I say rarely because, unlike so many other human rights in Australia, religious freedoms have not been, so far as I could see as president of the Australian Human Rights Commission, threatened in practice. Although that's what it seemed to me until I travelled a few years ago, 2 or 3 years ago, to Gosford on the New South Wales Central Coast to speak to the Gosford Anglican Church of St Mary. Some of you may know it. It's an historic church. It was built in 1858 in East Gosford, and it was later moved by parishioners stone by stone to its current spot. Its priest, Father Rod Bauer, is thoroughly modern, a rebel known for his advocacy for the most vulnerable in the community. Indeed, I believe he's now standing as an independent at the next election. He's long provided humorous support for the Australian Human Rights Commission's work, particularly for asylum seekers. And one week on the church's weekly message board was one that read, #We stand for Gillian Triggs. So I'm obviously a huge fan of Father Red Bauer. Well, my speech was really about the international legal principles protecting asylum seekers and refugees. And I thought my speech was going quite well. I was talking about the conditions of the children, the cruel and inhumane and, in my view, illegal treatment of families in detention. But, of course, after a speech which one can control, the Q&A session started, and I was asked about freedom of religion. And I repeated my understanding as a lawyer that the Australian Constitution, as interpreted by the High Court of Australia, protects that freedom relatively comprehensively. But I could feel the atmosphere turn quite chilly. And you learn this as a speaker. I do a lot of public speaking. And if you say something that the audience really profoundly disagrees with, the waves and the vibes come over very, very noticeably. Clearly then, the congregation did not agree with my rather sanguine approach that the Constitution protected freedom of religion. So, leaving Father Bauer and his parishioners, I returned to our Sydney offices of the Australian Human Rights Commission to look rather more deeply into a question that I had not really considered deeply myself. And it's true, I discovered, somewhat to my surprise, that protections for religious freedoms are not fully protected in Australia, and indeed typically only by way of exception. And an example of this is, of course, the Sex Discrimination Act of 1984, introduced by a former colleague of mine at the Australian Human Rights Commission, Susan Ryan. Many of you in the audience will remember her, the first woman to be appointed to a Labor cabinet. She had the confidence of Bob Hawke as Prime Minister, and he said, well, if you really want to bring into effect in Australia the Sex Discrimination Convention, CEDAW, then go ahead, you'll have my support. And as Minister for Education, she succeeded. And in fact, when I was having a rather tough time with the current government, Susan would sometimes put her head around the door and say, Gillian, if you think you have it bad, go back and read the newspaper commentary about me when I wanted to introduce the Sex Discrimination Act. She's a marvellous woman with her heart very definitely in the right place for women and indeed as a Catholic. Well, I mentioned the Sex Discrimination Act, and we'll come back to it a few times, because it provides an example of the drafting technique of lawyers and of Parliament in purporting to protect religious freedom. The Act makes it unlawful to discriminate on the basis of sex, among other protected attributes, in public life, including employment, education, the provision of goods and services, accommodation, and membership of licensed clubs. However, it also contains an article that provides various exemptions for the ordination or appointment of priests, the training and education of those seeking ordination or appointment, but most particularly the language or any other act or practice of a religious body that conforms to the doctrines, tenets or beliefs of that religion, or is necessary to avoid injury to the religious susceptibilities of adherents of that religion. So, to encapsulate that, it is quite common in anti-discrimination laws to have a prohibition, in this case of sex discrimination in relation to employment, education and so on, but to have an exception to that prohibition of where the act or activity is one of a religious body that conforms to its religious views and doctrines, or avoids injury to the religious susceptibility of those who are adherents to that religion. If Australian law enables religious bodies to avoid a legal obligation that is binding on the rest of us in the community, on the exceptionally wide ground that the act or practice conforms to beliefs, etc., then this exception is, or appears to be, generous and wide-ranging. What is it, then, that faith-based groups are concerned about? Is there any justification for their disquiet? Well, my colleague at the University of Sydney and a first-class legal scholar, Professor Patrick Parkinson, made it very clear to me that while religious freedom in Australia is protected by a series of exceptions, much more should be done positively to protect this right, as is the case for other forms of unacceptable discrimination on the grounds of race. One of the most important pieces of legislation for human rights in Australia is the Race Discrimination Act, the Age Discrimination Act, Disability Discrimination Act, and of course the Sex Discrimination Act itself. These are the four major pieces of legislation that underpin the human rights and complaint functions of the Australian Human Rights Commission. And I can attest to the fact that we had very, very few complaints to the Commission about breaches of the rights to freedom of religious expression. So are the concerns of faith-based groups that their freedoms are threatened overstated and unsubstantiated on the facts? Well, the answer is a rather unsatisfactory yes and no. And let me give you some examples of how the law has worked. One, a case that arose here in Victoria in 2014. It concerned the Christian Youth Camp and the Cobor Community Health Services. And the Cobor Community Health Services had applied to the Christian Youth Camp to have a booking for their facilities to promote gay rights education and a suicide prevention group. And the Christian Youth Camp declined to accept that booking on the grounds that to promote homosexuality in their view was contrary to its religious beliefs and it should not be legally forced to accept the booking. Well, the Victorian Supreme Court, that of course had the benefit of a charter of rights and freedoms and responsibilities, well known to you here in Victoria, found that there was a right to freedom of expression, but that as the facility was a public facility and essentially commercial in the public arena, then there was no right to decline the booking. And the High Court of Australia effectively confirmed that provision. In other words, there could be no discrimination in these. There would be discrimination in these circumstances because the facility was available at a commercial and public level. It created something of a furore at the time, but the notion of being in the public arena and for a commercial purpose gives you a clue as to how the contemporary debate has evolved in the years since 2014. It is also ironic that the area that the question of religious freedom has most particularly arisen has been in the context of sexuality, sexual orientation, and in particular, the same-sex marriage laws. And it's been ironic that the discussion of this issue of religious freedom has arisen in the context of marriage laws in a way that has possibly shone a light on the adequacies and inadequacies of those protections, in a way that's led to a review that may, in fact, reduce those protections rather than strengthen them. It's an extraordinary outcome of that public debate last year. I believe that the political debate on same-sex marriage was mischievous in some cases, with misinformation and advertisements, false allegations, and perhaps particularly that freedom of religion would necessarily be at risk. The No case argued that freedom of religion is not fully protected in Australian law, and campaigners feared that if marriage equality were to become law, people would no longer have freedom of speech and would be forced to accept practices that are contrary to their religious and personal beliefs. Well, these concerns may be overstated, but they nonetheless unnecessarily distorted and distracted the debate from the core legal question of equality before the law for same-sex couples. The national debate did have the merit of exposing the slender scaffolding, and that is something that's been very important to my work, upon which Australian freedoms generally are based. We have a very significant weakness in our protection system in Australia as a whole. While one might conclude that the amendments to the Marriage Act that have been now made appear to have achieved a reasonable balance between equality and freedom of religious expression, the debate has stimulated us to consider how we can better protect religious freedoms in the future. And indeed, we've now had the benefit of the Ruddock Review and its recommendations, and a fairly positive response from the Australian government. So I would like very much to see this discussion about how we can better protect religious freedoms take place away from the political and politicised environment, particularly, I hope, that it arises in the main after the next election rather than becoming entwined in the current election. There's so little time and so few parliamentary days left between now and the probable election that it may be that we will not actually ever see a draft of the religious discrimination bill, and hopefully we can have a discussion about it later with a new government if necessary, or possibly the current one, but in any event an environment in which it's not taking place in the context of a political debate, when I think that is when people are polarised and when we have high levels of misinformation. Well, what I thought I would do is to, in thinking about this and thinking about the Ruddock Review and the response by the government and the issues that it raises, is start right at the beginning, if you'll bear with me, to look at the law that protects religious freedom. And I'd like to start as an international lawyer with the right as protected initially by the Universal Declaration of Human Rights. I like to mention that declaration of 1948. It was not technically binding, but it was one that the rather irascible but brilliant lawyer, Dr. H.V. Evatt, played such a strong role in. He was invited by Eleanor Roosevelt after the Second World War to come back to Washington to help her, along with a very small number of other people, and the Australian government did, and he was, perhaps not always well known, the President of the General Assembly when the Universal Declaration was passed without a single negative vote. So we have a lot to thank H.V. Evatt for in helping to set the groundwork for the human rights law after the Second World War. But that provision, the right to religious expression, freedom of religious expression, was given concrete legal form in Article 18 of the International Covenant on Civil and Political Rights, one of the most important international human rights instruments. And what that does is to protect freedom of thought, conscience and religion, and it does so in two ways. Firstly, the right to adopt a religion or belief of one's choice. And secondly, and very importantly, a right to manifest that religion or belief in worship, observance, practice or teaching in public or private. Well, these two aspects of freedom of religion may at international law be subject to some limitations, only if they're prescribed by law and are necessary to protect public safety, order, health or morals, or the fundamental freedoms of others. Well, Australia very quickly became a party to the covenant, and we are bound by it in international law. We are bound to ensure the ability of parents to provide the religious and moral education of their children in conformity with their convictions, but manifestation of religious belief must not move across the line to national, racial or religious hatred that incites discrimination, hostility or violence. And finally, and it's important to remember this, at international law, the right to freedom to adopt a religion and to manifest that religion in public is so important that countries cannot derogate from it. So once they have agreed to it, they cannot derogate and say that there's a national emergency or a public emergency and deny those rights. So it is a fundamental principle of public international human rights law. But there are some important points to remember from the point of view of international law. The first is that the right to freedom of religion is not absolute, but must be exercised with respect to the rights and freedoms of others. So there's this constant balancing of rights, very difficult to do, and explains why this is such a difficult area of law, particularly in Australia. The international right to freedom to manifest religion is expressed by reference to individuals rather than by reference to institutions. And we'll come back to that point in a moment. It can be manifested in public and private, extends to conscience and of thought, and as well as religious belief. But now let us turn. That is the international legal position. Australia is party to the International Covenant on Civil and Political Rights. We have long championed these human rights, and we have been, I think it's fair to say, a good international citizen in supporting these fundamental rights, at least until the last 10 or 15 years. Australia's approach, however, to giving effect to international law in domestic law has been exceptional and isolationist. We are the only democracy and the only common law country in the world that does not have a charter or Bill of Rights. The difficulty, and in my view the great disappointment and the fatal flaw of Australian law, is that these treaties that we signed up to in those rather heady days after Dr. Evatt and other leaders in the Australian community in the 50s, 60s, 70s, all the way through to the 90s, the Refugee Convention, the Torture Convention, the Convention on the Rights of the Child, etc. Most of these conventions have never been implemented into domestic law by Parliament. And I think you'll all understand that it's one thing for the diplomats to go overseas with a mandate through the Governor-General to negotiate a treaty, but it does not have effect in our domestic law until Parliament passes a law to give it that effect. If they don't, we are in the extraordinary position of being in breach of international law, but complying with domestic law. And that stands up, that is illustrated most particularly in the context of asylum seekers and refugees and the indefinite detention of asylum seekers and refugees without charge or trial, contrary to something as ancient in the common law as the Magna Carta. But that's a general point. So by respecting the principle of parliamentary sovereignty, we have not given effect to so many of these laws, but that includes the International Covenant on Civil and Political Rights, and for our purposes today, Article 18. So that's the law we're bound by, but it's not the law that's been introduced into Australia. Well, what have we done? It is true to say, as I tried to say to Father Bauer's congregation in Gosford, one of the very few human rights protected in the Australian Constitution is the right to freedom of religious expression. There's no right to free speech, to association, to privacy. There's no prohibition on arbitrary detention without charge or trial by your peers, as in the Magna Carta. None of these rights are in the Australian Constitution. Very, very few were protected by the Founding Fathers when the Constitution was developed, with the exception of religious freedom in section 116. Before I mention 116 in detail, you might remember that in the preamble to the Constitution, it begins, whereas the peoples of New South Wales, Victoria, South Australia, Queensland and Tasmania, humbly relying on the blessing of Almighty God, have agreed to unite in one indissoluble federal commonwealth. So we have a reference in the preamble to Almighty God and the blessing of Almighty God, not defined, of course. But then we move to section 116, which was primarily a safeguard against religious intolerance in Australia. That was the great concern of the drafters of the Constitution in the 1890s. And what section 116 does is to prohibit the Commonwealth, the new Commonwealth that was going to come into being, from making any law establishing any religion. That was the fear. They did not want an established religion. But in so doing, they also prohibited the Commonwealth from making any law prohibiting the free exercise of religion, from imposing any religious observance, or imposing a religious test as a qualification for any Commonwealth office or public trust. So it was quite a liberal and modern provision in its determination to ensure that the Commonwealth Parliament would not make laws that would impinge the religious tolerance that was seen as so important to the foundation of the modern Australian Commonwealth of Nations. It was a huge thing what they were doing, creating the unity of the Commonwealth, and they did so on the basis of strict religious tolerance for all religions. No law may be passed that prohibits the free exercise of any religion. Well, the High Court of Australia has interpreted the word religion extremely generously, including atheism and agnosticism. And you will remember, some of you, the Scientology case, the Church of the New Faith against the Commissioner for Payroll Tax in 1983, recognised Scientology as a religion for the purposes of the Charities Act, which is where these things tend to come down. But also, the High Court has made a number of important decisions that have helped us understand what the protection of religious freedoms under Section 116 actually means. One is the Dogs case, where the High Court found that non-government schools funding is constitutionally valid and does not impinge upon the rights of Section 116. So it allowed the Commonwealth Government to fund non-government schools. We also had the school chaplaincy decision in 2012 that the chaplaincy was not, because it was constructed actually under the Commonwealth, and that the Commonwealth could in a sense outsource the chaplaincy role as it had done. While the chaplaincy funding was struck down by the High Court, it was struck down on a very different ground, and that is that there was no legislation to support the funding, and therefore the funds couldn't validly be made, and that has been repaired. The main point then is that the constitutional protection for religious beliefs is as close to the best protection one can get from coercive laws, but the High Court has nonetheless interpreted the provision relatively narrowly in some areas. For example, it tends to accept certain burdens on religious beliefs as being consistent with our representative democracy. One is Krieger against Williams in 1912, a very long time ago, where the High Court decided that compulsory peacetime military training did not contravene the prohibition on the free exercise of religion. Now you won't recall, but you will know from your studies that at that time one of the greatest issues for religious freedom was the right of people to be conscientious objectors to compulsory military service. And the High Court said, no, a religious objection to serving in the military was not an improper burden and was constitutionally valid. Laws that remove the tax exemption for religion will also be valid, as will any proportionate laws that's necessary to protect social order. One was struck down a couple of years ago in New South Wales where it was an offence during the Pope's visit to behave in a way that annoyed other people coming to see the Pope. Now the High Court struck that one down as an impermissible and disproportionate burden and not really necessary to protect the social order. So we haven't had many cases that have actually explained what this means, partly because, as I've said earlier, it hasn't really arisen in practice very often. You only get it in the context of particular issues, military conscription or protections for the Pope when he visits Australia. Well, let's get back then to the way in which this has worked, because for the most part, and it's true to say that despite those constitutional protections which seem strong, certainly to me when I was worried throughout my time as president that we had so few constitutional protections for human rights, it was very difficult to argue for those with mental illness, for the homeless, for asylum seekers and refugees, because there were so few tools to use in the Constitution itself. However, we do have a raft of laws that have been passed by Parliament that protect us and protect the right to freedom of religion through this phenomenon of the exceptions. And the main ones have been developed in the context of the Sex Discrimination Act, so that there are exemptions for religious organisations from discrimination laws in relation to employees and contract workers, and they may not, while they may not discriminate on the grounds of sex, marital status or pregnancy, and students may not be discriminated in respect of marital status and pregnancy, religious organisations will be exempt from those provisions. The Labor government introduced some further amendments in 2013 when they added to sex, marital status or pregnancy, they added the protected criteria of sexual orientation, gender identity and intersex status. I'd been president of the Commission for only a year when the Labor government introduced that amendment, and I thought that it would not be accepted, that it would be rejected at a community level and particularly by people of faith. But to my astonishment, it attracted almost no objection at the time. It went through with very little public debate and has, of course, expanded the exemptions for religious institutions in relation to those areas. So that's the point. Critically, the legislation that protects against various forms of discrimination have almost invariably given exemptions to religious bodies. And there are also exemptions that allow religious organisations to discriminate in delivering goods and services, including marriage-related services and facility hires, again on this test that you hear over and over again, in accordance with religious doctrine, tenets or belief, or to avoid injuring the susceptibilities of their adherents. Well, how then does all this work? It does mean that a religious organisation can refuse to employ a person in a same-sex marriage if refusal conforms to the doctrines, tenets or beliefs of that religion. But it's worth observing now that everything I've been describing in relation to the Sex Discrimination Act, and it's true otherwise in other acts, protects the institutions, but it does not extend to individuals. But you will recall that Article 18 of the International Covenant on Civil and Political Rights applies to individuals and doesn't mention institutions. It's a very interesting shifting of the international to the domestic. And for many of us in faith-based communities, the concern is less about the institution or the organisation than it is about the individual's need for freedom to express their religious views. And that is really where we get into these difficult cases of bakers baking cakes and providing goods and services. But let me make this even more complicated than I already have. by raising something that Susan Ryan is also somewhat responsible for. And this is the exception to the exception. So you're going to need to hold on to your seats a bit. We have a constitutional protection of the right to freedom of religion. We have anti-discrimination laws that typically exempt religious institutions. Now we have an exception to that exception. In what area? It arose in the context of Commonwealth-funded aged care facilities. The government told us at the Commission that they were very concerned about allowing exemptions for faith-based groups in relation to aged care facilities where they are funded by the Commonwealth. And what did we think about excluding or accepting the exception, denying the exception to faith-based bodies? Well, we did our own research across the faith-based bodies across Australia, and we found that almost all of them said that they would never discriminate against a same-sex couple in offering aged care facilities. Now, I didn't ask the most senior bishops and archbishops, but we did ask more middle-level representatives of the religious groups, and that was the answer we got. Now, it's important because, as you may know, 64% of aged care facilities are provided by faith-based groups, and they receive public funding. Now, the argument that was made through Susan Ryan and the Australian Human Rights Commission was that we could see a good argument for denying the exception in relation to Commonwealth-funded aged care facilities. And again, to my complete astonishment, that amendment was successful and the government got it through. But I raise it, one, just to give you an illustration of just how complex this law can become, and why I think there's so much misinformation and confusion in the public arena in some areas, but also that once you introduce the argument that if a body is substantially publicly funded, that institution and those employed with it must meet the standards of the community generally, religious tenets or beliefs will typically not be accepted as an exception. So when I said it was ironic that we've had this debate about same-sex marriage that has exposed the flaws in the protection for religion, it's actually added fuel to those who want to deny the exceptions as they currently exist. In other words, the protections could become weaker rather than stronger on the fundamental point that if faith-based bodies are receiving public funding, they have to meet the same discrimination or anti-discrimination laws as everybody else. And reasonable minds will differ in relation to it. And it is a very difficult issue to resolve. The issue of marriage equality I'll touch on very briefly, but you will know now that that debate is now over. The challenge was to somehow balance the right to equality before the law with the need to protect religious freedom. And I think for the most part that has been achieved fairly successfully in allowing ministers of religion to solemnise marriages and to refuse to do so in relation to same-sex marriage to the extent that that conforms to the doctrines, tenets and beliefs of that particular religious organisation. Well, one of the arguments that was made by the No case was that there are risks to the right to freedom of speech. And as is very often the case with a successful public campaign, or even an unsuccessful one, that might be broadly misleading, there is usually a kernel of truth that sustains the debate. And this was particularly so with regard to the American case law on the First Amendment protections for freedom of speech, which of course we do not have in Australia. But you might recall that there was a decision early last year that was talked about a lot. It was a Los Angeles case of compliance with California's non-discrimination laws, the Make Peace cake shop case, where a same-sex couple asked a baker to bake a special cake for their wedding. And that baker argued that as a Christian, she did not believe that same-sex marriage was accepted within her understanding of biblical teachings, and she said she had a First Amendment right not to bake that cake. Well, the judge, the superior judge in California, said, and this is very much an American approach to First Amendment speech, which they protect almost without exception. They said, when she was asked to make that cake, that was an exercise of her creative ability. Why should she be asked to bake it for this couple when she so profoundly disagreed with what they were going to do, which was marry? And he said that she was entitled to First Amendment speech, and that in a way, ousted or trumped, although I don't like to use that word, the right to freedom of religion, which is also, of course, strongly protected in the United States, given its historical and constitutional background. Now, the matter is now before the United States Supreme Court, and we'll see what the outcome of this challenge is going to be. But when I read that case, although sometimes as you start off reading a case, you've got a clear view of what you think it ought to be. When you read what the judge has got to say, it quite often moderates your view. There is something to the argument that she had a creative contribution to make to this cake, and she did not want to use that creative capacity as part of her own freedom of expression to support something she didn't believe in. So how do you find the right answers to those questions? I really don't know. I suspect they come up so infrequently that we really shouldn't be overly diverted by it. And if perhaps I could say at a personal level, if I were asking for that cake from her and she declined for those reasons, I think I would respectfully say, that's your view, thank you very much, I'll take my order somewhere else. In other words, let the marketplace resolve it and do it courteously and respectfully. I don't think we need to use it as a basis for arguing that we need to reform our laws. But there was one case closer to home that did raise some very difficult questions for all of us, and it was very worrying from our point of view at the Human Rights Commission, and that is, you might remember the Tasmanian complaint brought in relation to a booklet published by the Australian Catholic Bishops' Conference called Don't Mess with Marriage. It was quite a measured, moderate presentation of the Catholic view. But a transgender rights activist, Martine Delaney, strongly objected to the booklet being sent to parents of Catholic schools, and she brought a complaint to the Tasmanian Human Rights Commission. Now, we have to remember that I've been talking so far about Commonwealth law, but some states do especially protect the right to religious freedom. And Tasmania is one of them, and one of the strongest states that does so. And it is a protected attribute that the Tasmanian Human Rights Commissioner is entitled to consider. And she felt with a very low threshold there was an apparent complaint and an apparent conflict with religious freedoms, and she took the matter on with a view to conciliating the matter, which is the job really of human rights commissions, and certainly my job with over 20,000 matters a year at the Australian Human Rights Commission. The job was to try to bring people together privately, confidentially, not as a legalistic exercise, but as something where they could each understand the other's position and reach a compromise. And in 76% of cases at the Human Rights Commission, we did in fact achieve that compromise. But this was one of those cases that went straight out into the media and fed into the debate. The point then being that was the conduct one which contravened the right to freedom of religious expression, and the Catholic Archbishop or Bishop very strongly supported the booklet and said that were they to be denied the ability to produce this booklet, even though it might have offended the particular complainant, would be a significant diminution in their right to freedom of speech. Now, that was used as an example by the media to show that anybody who spoke out against same-sex marriage would be immediately subject to the complaints processes of human rights commissions, and that this was wrong and that it was unnecessarily confrontational, that we had to go about this in a different way. Now, as it happened, the complaint was withdrawn. It couldn't be conciliated. It was withdrawn, and that was the end of the issue. But it created a sense of fear in many in Australia that you could be prosecuted under, in that case, Tasmania's laws that protected freedom of religion, but which also prohibited offending, insulting, humiliating, and ridiculing another person's religion. So that was the balance in Tasmania. The matter has gone away, although other matters have subsequently been brought to the Tasmanian Commission, but which are being handled in a more conciliatory way in relative privacy. But that fueled the debate that the right to freedom of religious expression was being impinged upon. A rather poor case, I think, because the document itself was clearly a moderate and modest attempt to inform parents just what the consequences of these proposed amendments would be. Well, now we come to the Ruddock report. In light of all of that and the unfortunate circumstance in which the limits of the protection in Australia of human rights, but religious freedom in particular, were being brought into the public arena, we now had a reference to the Ruddock panel to advise the government as to what could be done to protect religious freedom more effectively. And the Ruddock report went straight back to Article 18 of the International Covenant on Civil and Political Rights and said it is a human right for the religious, the non-religious, and those who subscribe to other systems of belief to have protection of the legal system. The core challenge they saw was to remove exemptions with respect to a person's sexual identity while also protecting the right of religious institutions to act consistently with their religious ethos. The main recommendations were that religious freedom should be protected by a positive law wider than the mere exceptions that I've been describing to you, which are hard for me to explain and hard for the Australian public to really understand. Certainly exceptions to the exceptions is just simply too convoluted and difficult for anybody to understand. You can see the merit of a positive protection. If we protect against discrimination with regard to race, sex, age and disability, one would have thought, in light of the leadership through the Constitution itself, that we would have a protection for religious freedom. The other recommendation is that religious schools should not be able to discriminate against gay staff and students, and a recommendation that there should be an expansion of the right to religious freedom to individuals as well as to the institutions, which is a huge change from the current position of law. Well, the government accepted 14 of the Ruddock Review's 20 recommendations and will seek bipartisan support for one of them, that is the introduction of a racial discrimination bill, and it will send the other 4 to the Australian Law Reform Commission to see what their advice is. So the idea is that the government will introduce a religious discrimination bill along the lines of other anti-discrimination laws. We haven't seen, or I certainly haven't seen, what that discrimination bill looks like. And as I said, I think I'm very cautious about wanting to rush with it because I'd much prefer that it be dealt with or introduced after the election when we can deal with it in a calmer environment. But basically the government intends to render it unlawful to discriminate on the basis of a person's religious belief or activity, including not holding any belief, with some exemptions for religious bodies, schools and charities. But in producing a bill like that, maybe it will become an act, we would have a positive protection for religious freedoms and freedoms not to have a religious belief, with some appropriate exemptions for religious faith-based groups. But this time, if it is successful, we would have a positive statement rather than relying on a series of exceptions. The government also suggested and accepted the panel's view that the many exceptions in relation to race, disability, pregnancy and intersex status that differ across federal, state and territory jurisdictions should be reviewed at the state level. So we have a mishmash of extremely, I've just tried to describe the Commonwealth law, I haven't got really down to describing the state and territory laws, very confusing, very hard to understand, with all sorts of inconsistent outcomes. The government has said that states should review these laws in light of community expectations. Now that's a very broad phrase, I don't know what it is, where it's going to take us, but that is the suggestion. The other proposal is that the government would create a commissioner for religious freedom appointed at the Australian Human Rights Commission. That is contrary to the review panel's recommendations. They didn't think that this was necessary, but the government wants another commissioner to represent religions in particular. And lastly was the suggestion, the government has accepted the recommendation that there should be an abolition of blasphemy laws wherever they exist at the state and territory levels. Now, the controversial recommendations, I'll now go through. They're 5 to 8, numbers 5 to 8. Recommendation 5 is that the Commonwealth would amend the Sex Discrimination Act to allow religious schools to discriminate on the basis, in employment, on the basis of sexual orientation, if it's founded on religious precepts. And here's the new bit of law. There is a clear, publicly available policy, so that someone who might apply for a job at a school of a different sexual orientation would be well aware of how that practice related to the religious precepts of that body, and it would be a publicly available policy. So it's not all that different, but really just asking for a clarification of what are the religious precepts of that organisation, and having stated them clearly, then seeing that they are available in the public arena. Recommendation 6 is that there should be an abolition of exemptions with regard to employment discrimination in relation to race, disability, pregnancy and intersex status. Recommendation 7 is that the Sex Discrimination Act should be amended to allow religious schools to discriminate in relation to students on the basis of sexual orientation, gender identity or relationship status if founded in the precepts of religion and the best interests of the child are the primary consideration, and the information is again publicly available. This is the controversial part. And I have learnt to my sorrow really that a great deal of careful, factually and policy-based reports in the public arena can be completely discarded because of one perceived flaw. In other words, you can lose everything because of one issue. And this is the issue that I suspect is going to be the biggest and the most controversial. Of course, there's always ground for compromise if this were to be put in any legislative form, but I'll just repeat it for clarity. The recommendation is that the sex discrimination should be amended to allow religious schools to discriminate in relation to students on sexual orientation grounds. I think you can see that after the success of the same-sex marriage debate, for which I understand the overwhelming majority of the Catholic community, for example, voted in favour, there's a very strong sense within the community that you cannot discriminate against students because of their sexual orientation. And I think that's going to be possibly the most difficult element of this legislation. And finally, then, to pick up that point, that any exceptions to discrimination law with regard to race, disability, pregnancy or intersex status should be eliminated. In other words, in summary, the aim is to eliminate some of the exceptions that currently exist in our law, but to add one or two others, to expand the notion of religious freedom to individuals consistently with international law, and to create a new commissioner for religious freedom, and to have a positive law that protects that freedom in the legislation itself. Well, if I may, I'd like to very briefly end by giving you perhaps my own view with regard to this, because as I've suggested at the beginning, one of the greatest concerns for me as President of the Human Rights Commission on issues that were particularly important during my time was that there were no rights in the Constitution and very little legislation that would allow one to argue against the indefinite detention of families and children in asylum seeker children in detention. And that because we have not given legislative effect to the Convention on the Rights of the Child, the Refugee Convention, the International Covenant on Civil and Political Rights, I had very few tools as President for my legal advisors when we went to court or when I would see the minister. I might see the respective minister raise these issues, and the minister would say quite correctly to me, "That is very interesting, Gillian, that there's a prohibition in the International Covenant on Civil and Political Rights on detaining children and families indefinitely in offshore facilities without charge or trial, but it's not part of Australian law. Australian law is exactly to the contrary of it." So I was always struggling. Now, I can see the merit in the recommendations, broadly speaking, without going into too much detail about the exceptions. I can see the merit of a positive anti-discrimination law that protects religious freedom. But what I have trouble understanding is why you would prefer to give a special priority to that freedom when we don't protect by legislation, if fully, the prohibition on arbitrary detention. We don't protect privacy. We have no laws against, we don't protect properly the right to protest, the right to freedom of association, and most particularly the right to freedom of speech in full terms. So why would you pick one more? Well, the answer to that might be because we've done it already. We've done it on race, we've done it on age, disability and sex. Why would you object to it? I don't object to it. What I see for the future and what I've been arguing for is that it is time that Australia reconsidered the national consultations run by Father Frank Brennan for a Charter of Rights. I'm not proposing, and nor did he, I believe, I'm not proposing a constitutional amendment with a Bill of Rights. We can't get recognition of our own Indigenous peoples through constitutional amendment. I'm being politically practical. We won't get it. We won't get a Bill of Rights in an entrenched way like the United States, nor do I think we should. We are not the United States. We have a great faith in our parliamentary system. It's been called into question in the last few years, but nonetheless, we as a nation want to believe in parliamentary representative democracy. It needs improvement, but that's where we are. I think we need to go back and look at something like the Victoria's Charter of Human Rights and Responsibilities, the ACT's Charter for Rights and Responsibilities, both of which have a right to protection of freedom of religion and religious expression. Let us look at the wider picture and bring in a piece of legislation. Legislation is fragile. A government can come in the following year and redo it. But do you know, in the entire history of countries that have adopted human rights acts, not a single country has ever repealed it. They play around with them. They threaten to repeal them, as in the United Kingdom, but they've never done it, and they probably won't. They'll amend them, and that's entirely appropriate through the parliamentary processes. So let's not be frightened of it. And it's not going to give judges huge power. There will be the dialogue model that we have in Victoria, where the courts don't have a right to declare totally invalid a piece of the Victorian Parliament, but they ask the Parliament to go back and reconsider it because it's not consistent with the provisions in the Charter. That is where I'd like to see this discussion go. But if we end up with legislation that protects religious expression, then I'm all for it. But I would much prefer to see the wider debate in a way that protects wider freedoms, the right to a home, the right to a basic income, the right of access to the courts, the right of protection for our Indigenous peoples and protection of their culture and spirituality. Let us look at it in a wider way. I think it might be more productive. But thank you very much for the opportunity to speak on this very important issue. Thank you.